The first was a purchase agreement for 10 acres of residential land for semi-secure at 2 million, notably below the prevailing market value. Driven by acute financial distress and the imminent threats of bankruptcy, Semi felt compelled to accept this offer to settle his mounting business debt and stave off legal action from his creditor.
The issue is, can Sami rescind the agreement that he signed under duress and make the offer of the agreement valid?
It's FARHANA FATIN BINTI NURSAN and my metric number is S6094. According to the Section 50 of Malaysian Contract Act 1950, coercion is defined as unlawfully holding property or conducting or threatening the commit forbidden activity in order to force someone to accept the agreement, which is may be avoid leasing agreements. In Section D2 of Contract Act of 1950, define consideration as the value change between party in the contract is referred to act or abstain made by the promisor or other person at the promisor desire, such as in a lease agreement when the rent is paid for the right to occupy the property. 60 of the Contract Act 1950 state that the contract can be avoidable if was entered into under influence where one party unfairly pressure another party to enter the contract, potentially affecting the fair market value and agreement through attention or interest.
Application. So, Section 15 state any act that is forbidden by the Penal Code that causes any person to agreement into an agreement. In semi case, indirectly there is no existence of coercion by Masendran Berhad that caused Semi having to accept an offer from Masendran Berhad because he had financial problems, namely business debt that were caused the threat of bankruptcy. This may constitute economic duress since Semi did not voluntarily want the offer. This caused Semi to accept what Masendran Berhad offered even though it was unreasonable. Thank you.
My name is MAISARAH binti Ibrahim. My metric number S66907. For conclusion, issue number 1 is Semi is unlikely to success in rescinding the contract based solely on financial distress unless he can demonstrate undue influence or coercion by Masendran Berhad. The inadequacy of consideration claim is also weak without evidence of exploitation.
Fact. So, Masendran Berhad entered into a lease agreement with Leong for an office building. With the monthly rent set at 105,000, reflecting the market rate at the time. Next, the economic recession at the time due to the epidemic had caused Leong to look for reliable tenants. Lease terms are usually flexible, allowing Masendran Berhad to occupy the premises as long as the company wants, with no defined end date. After that, Leong received a more attractive rental from other prospective tenants. This prompted him to reconsider his agreement with Masendran Berhad. He sought to rescind the lease, argue that its indefined duration made it invalid.
So for issue number 2 is other terms of the agreement, particularly a fair share of the profits, sufficiently certain to be enforceable under Malaysian contract law.
The law is Section 30 Contract Act 1950. Agreement, the meaning of which is not certain or capable of being made, certain are void. This provision simply holds that any agreement whose terms are obscure, that the meaning cannot be ascertained, is void and unenforceable. The reason why this section has been developed is that for a contract to be valid, the terms of the contract have to be clear and definite so that the parties know what they are getting into. Where an agreement is too vague, it cannot amount to a legally enforceable contract. The example cases for this case is Karupan Chetty versus Swatiam 1960. The second one is Smith versus Hugh 1870. The third one is Atenas Ltd versus Rakal Defense Electronic 2000. And the last one is G. Scammell and Nephew versus Hayes C. and J.G. Outston 1941.
This agreement between MAISARAH Berhad and Leong, which lack a definite end date and uses a term for as long as the company wishes, create ambiguity and is interpreted as a tenancy at will. Under common law, this allows either party to terminate the lease with reasonable notice. Leong cannot unilaterally invalidate the lease without providing such notice. To legally terminate the lease, Leong must give MAISARAH Berhad reasonable notice to vacate the premises. If Leong fails to provide the notice and attempts to evade MAISARAH Berhad abruptly, MAISARAH Berhad may have legal grounds against him. Thus, Leong can terminate the lease but must follow proper legal procedures to avoid legal repercussion.
In Part 2, Leong has a stronger case to terminate the lease due to the indefined nature. Courts may require a reasonable notice period to end the lease and allow Leong to potentially accept the new tenants with the better offer.